Good evening to all the participants of the Telangana state as well as the Andhra Pradesh JCJ 2023. Participants, are you hearing me?
Yes, sir.
Could you see my screen also?
Yes, sir.
Yes. Could you read my screen?
Welcome to the aspirants of AP+TS+JCJ 2023 MCQs virtual class on 23rd 2023 Indian Standard Time from 9:10 p.m. to 10 p.m. The IPC code 1860 Professor Dr. Mahmood S. Hussain.
Thank you very much. Now let us shoot it because, yes, the first question. Be ready. Yes, I am also recorded. Yes, it is in progress. A man is said to commit a rape if he does any of the following. I believe that everybody is a major here, so need not worry. Take it as a sportive manner. Which one is the correct option? Number one, enters his penis to any degree into a woman's vagina, mouth, urethra, or anus, or forces her to do so with him or another person, or 2. Forces any item or body part other than the penis into a woman's vagina, urethra, or anus to any extent, or 3rd. Puts his mouth to a woman's vagina, anus, or urethra, or make her to do so with him or any other person, or 4. Manipulate any portion of the woman's body in such a way as to induce the penetration into her vagina, urethra, anus, or any other part of his body. Yes, now here I have given A, option 1 plus 2 plus 3, B, 2 plus 3 plus 4, C, 1 plus 3 plus 4, D, 1 plus 2 plus 3 plus 4.
D, 1 plus 2 plus 3 plus 4.
WRONG. If you closely observe, 4 is the wrong answer. I will show you the reason. Manipulates any portion of the woman's body in such a way as to induce penetration into her vagina, urethra, anus, or any other part of her body, not his body. Is it clear?
Yes, sir.
So this is the wrong statement I made, but other things are as usual. So the right answer is
Option A, 1 plus 2 plus
1 plus 2 plus 3. See, in this way also they can ask the question. And be ready because I am giving all type of the angles so that my students should not keep the zero face, withered face, pale face, faded face. That is my intention. Feedback already I have given you. The second question. Yes, anyone can unmute and read the second question.
The first foreign nation to pass reforms for marital rape was Dash in 1976, and after its many Scandinavian and European countries also recognized marital rape as an offense. Option A, America. Option B, India. Option C, Australia. Option D, Canada.
Which is the first country where the marital rape was recognized?
Option D, Canada.
WRONG. Second option.
Australia, sir.
If you say option A, America, WRONG.
Australia, C.
Australia is the right answer. C. Australia is the first foreign nation to pass reforms of the marital rape was Australia in 1976 after its many Scandinavian and European countries also recognized the marital rape as an offense. Which are the Scandinavian countries? Anyone? Supplementary question?
Azores.
7 Scandinavian countries are there. The Nordic region consists of Denmark, Norway, Sweden, Finland, and Iceland, as well as the Faroe Islands and Greenlands and Ireland also joined over there. These are the Scandinavian countries. Then the European countries, 44 countries are there, European countries. Now, what is the supplementary question? European countries, what is the currency now?
Euro.
I appreciate. Can you know the value of the euro currency now? Sir, we don't know.
No,
But
sir.
to my knowledge, I think only Kuwait dinar is highest. Next euro is the highest. Okay, 44 countries are there total. We need not worry about that, those, because United Nations are, of course, all the countries, UK comes over there, France, Italy, European, that German, Netherlands, these are all Belgium, these are all countries comes under the European countries, including the Turkey. In the Turkey, half of the part is Indian, half of the part is European. There is one river is there. So that will divide it. Okay, third question. The Justice Dash Committee was given the responsibility of the recommending the changes to India's rape laws in Dash, while some of the ideas were implemented into the Criminal Law Amendment Act that approved in others, such as there are two dash are there in others such as the one regarding the marital rape were not. Number one, Santanam Committee. The next gap is 2012, Swaminathan Committee 2011, J.S. Verma Committee 2012, Iyengar Committee 2011. Of course, A, B, C, D, I did not make it out. Okay, now you shoot here.
A. Santanam Committee.
Repeat.
2012. A. Santanam and 2012.
Wrong. Try second option.
J. Swarma Committee in 2012.
Yes, that is the right answer. J. Swarma, that is the C is the right answer. J. Swarma Committee and 2012 is the right answer for the above question. Now the fourth question. The notion of the criminalizing marital rape was rejected in Dash at a parliamentary session with the argument that the marital rape cannot be applied in the country as marriage was viewed as a sacrament or sacrosanct in the Indian society. In which year rejected marital rape? A. 2013, B. 2014, C. 2015, D. 2016.
2015.
Yes, it is rejected in the 2015. And fifth question. With the advent of the separate and independent legal identities for husband and wife under the Indian law, the protection of women is a major focus of contemporary jurisprudence. Therefore, it is past duty for the legislature to recognize this legal flaw and repeal dash of the IPC in order to bring the marital rape inside the ambit of the rape legislation. I say which section and which exception? A. Section 375, exception 1. B. Section 375, exception 2. C. Section 377, exception 1. D. Section 376, exception 2.
376, exception 2.
WRONG.
C, sir. 376, exception 1.
375, exception 2. Now marital rape is there. To my knowledge, Indian civilization, either man or woman, they are fear of God. And hence, there should not be marital rape. That's my view. Otherwise, a woman who want to harass the husband, they take the advantage. Means advantage is more for the woman to harass it. But anyway, that is a different story. But now, marital rape is there. Is it clear?
Yes, sir.
Okay, sixth question. Unmute and read.
This landmark case, the Honorable Supreme Court
I said
concluded
this
that
is the
every
sixth case. Sixth case.
in my opinion, freedom of speech is something that every individual dash by birth, and hence it cannot be curtailed by any means. Option A, receives. Option B, gets. Option C, inherits. Option D, come into. Option C, inherits.
Inherits is the right answer. That is the right terminology. In my opinion, freedom of speech is something that, in my opinion, means Supreme Court opinion, every individual inherits by birth, and hence it cannot be curtailed by any means, because human rights are inalienable. Seventh question. Dash this landmark case, the Honorable Supreme Court concluded that every activity which is intended or likely to cause or disrupt public peace and harmony by resorting to the violence should be criminalized. Appellants could best be described as the measures taken by the government and its officials to resolve the current crisis quickly and effectively. In addition, it went on to say that they were not created to irritate others or tend to create disorder by violence or disturb the public peace. In which case law it is decided? Landmark case law. A. Kedarnath Singh versus State of Bihar. B. Ramnandar versus State of UP. C. Vinod Dua versus Union of India. D. All of the above.
Option A, Kedarnath Singh versus State of Bihar.
In all the cases, it is decided in the same manner. But to my knowledge, yes, Kedarnath Singh versus State of Bihar, I believe, is the right. Let me check it once again, because I prepared, I have got the doubt both Vinod Dua versus Union of India and Kedarnath versus. Let me check it so that it will be very clear to us, because we can easily make it out by checking. Let us see that, because I have the ability doubt. Criminal procedure trial. Ramnandan is in it. Jacob Judge. I think Kedarnath. Is it given here? Criminal is the court preceding trials. Reportable Supreme Court. Not all the above is correct. Of course, all the above also deals the things. All the three things also will be dealt. But one is actually the case law which is given is different. But anyway, let us check if the time is there again without wasting the time. Time being, we can say it's a Kedarnath Singh versus State of Bihar. No, sorry. It is a Vinod Dua versus Union of India.
Ramnandar versus State of UP.
Yeah, now I made it clear. It is a Vinod Dua versus Union of India. Is it clear?
Yes, sir.
Yes, I got the clarity, I got it. It is Vinod Dua versus Union of India, it is decided. Then eighth question. Which one is the correct option among the four options? Number one, Section 403 of Indian Penal Code 1860 defines the misappropriation of property. 2. Meaning the word misappropriation means dishonest misappropriation and use of another's property for the sole purpose of the capitalizing it as one's own. And Makazi, I am now online. Can I call you later? Now I am online. I will call you later. I am online now. I will call you later. Thank you very much. Okay. Now, the third point, criminal misappropriation takes place when the position has come innocently, but it continued to do subsequent change of intention or after knowledge of some new facts which the party was not previously acquainted. These are the number 4. Retaining property becomes wrongful and fraudulent when the fact is known. These are the 4 options are given. And among them, I have given here A 1 plus 2 plus 3, B 2 plus 3 plus 4, C 1 plus 3 plus 4, D 1 plus 2 plus 3 plus 4. Among the four, which is the A, B, C, D right answer? Shoot, even though it is wrong. Are you
2 plus
present?
3 plus 4, sir. Yes, sir. B 2 plus 3 plus 4.
Wrong.
D 1 plus 2 plus 3 plus 4.
Yes. I did not change it. I want to see that whether you can make it
Sir,
up.
but in option 3, it's criminal misappropriation text place. No, sir. Takes place.
No, text take place when the position has come on, but he committed to the
Takes
subsequent
place.
intents afterwards. But anyway, then I don't think that I changed it there. The criminal misappropriation text place. No, we can use the text
Takes
place.
place.
No, we can use the
Acha,
text
okay.
place. No matter. There is
Okay.
no grammatical mistake. Text place when the position has come innocently but continued. Actually, I would like to change it here because it deals only the property. I was thinking to keep somewhere in the immobile property. So that will be the wrong answer. But later on I found it, okay, let us make the question in this way also and to see that, no, there is some change I made it. Yeah, because I wrote in the feedback. Something changed. You check it again. What is the change I made it? Check again. See, if you happen to see the second, meaning the word misappropriation means a dishonest appropriation. And what I wrote here?
Misappropriation.
Dishonest. And a misappropriation and appropriation. So 2 is wrong. Then the right answer is
C.
C is the right answer. Is it clear?
Yes, sir.
Yeah. Of course, very rarely such questions may be asked. But I want to see that my student should not keep the zero face. Very rarely such questions will be asked, but they may also place out of the 4 statement, which statement is wrong also they can make it out to test your IQ. Now let us go to the next question, 9th question. Conversion of the property. For the constituting an offense criminal misappropriation, the essence behind this section is when a person converts any property for his own use. The word converts to his own use connotes the usage or the deals with the property in derogation of the right of the owners as per dash, which case law. And here given A. Sunil Kumar Pal versus State of West Bengal. B. Ramaswamy Nadar versus State of Madras. C. Yashdeep Trexim versus Board of Industrial and others. D. High Court of Punjab and Haryana et versus Mejas Atma 2 Products Limited and others.
Option B, sir.
B.
Ramaswamy
Ramaswamy.
versus the
Yes,
state of
it
Madras.
is a B. Ramaswamy Nadar versus State of Madras. This case is decided. So the B is the right answer for the 9th question. Now 10th question. In the case of Dash 1964 within parenthesis, the Supreme Court of India held that section 405 of the Indian Penal Code requiring doing something wrong in the property in the form of dishonestly misappropriating or using the property to satisfy own purposes or to capitalize it for own use or dispose of that property in contrary to a law that prescribes how to discharge such a trust or in violation of any contract, express or implied. The apex court also held that mere dispute which is of civil nature does not attract the provision of this section. See, the last point is more important. The apex court also held that mere dispute, which is of the civil nature, does not attract the provision of this section. A. Dinabandhu Banerjee versus Nandini Mukherjee. B. Pradeep Bhupatrai Vasa versus Bombay Builders Private Limited and others. And C. Shanmugam versus State of by Inspector of Police. And D. Mohammed Suleiman versus Mohammed Ayub and others.
Option D, sir. Mohammed
D, sir.
Sulaiman versus Mohammed
Yes,
Ayub
it's a
and
Muhammad Suleiman versus Muhammad Ayub and others. And this case law is made it very much clear. There is the Supreme Court of India held Section 405 of the Indian Penal Code requires doing something wrong. So that is the entire things which I read belongs to the D is the right answer for the question. Now 11th question. Which option is the correct or the right option among the 4 options? Here I have given the 4. Now let us see that where I committed a mistake or I fabricated a mistake. Number 1, criminal misappropriation and criminal breach of trust are not the same. Criminal breach of trust includes the criminal misappropriation, but the reverse is not always true. 2. Also, there is a huge difference between the criminal misappropriation and theft. And 3. Section 378 of the Indian Penal Code deals with the provision related to theft. 4. Under theft, consent of the real owner of the property is not known to the offender, but in criminal misappropriation, initially the owner of the property grants consent to the offender. Now options: A. 1 plus 2 plus 3, B. 2 plus 3 plus 4, C. 1 plus 3 plus 4, D. 1 plus 2 plus 3 plus 4.
One plus 2 plus 3. Option A.
So what is the wrong in the 4?
Without consent.
Under theft, the consent of the real owner of the property is not known. Because it will not be known, I said. Consent of the real owner of the property is not known to the offender. But in criminal misappropriation, initially the real owner of the property grants consent to the offender. So, I did not change anything. So, the right answer is?
Option D.
Option D is the right answer. See, such questions, yes, probability is there, they ask, but I want to see that you should be very much trained. Each statement you have to write it, read it and see whether it is appropriate or not, or any mistake is there or not. When you feel that when there is no mistake at all, at that time shoot the last one, 1 plus 2 plus 3 plus 4. But generally, they don't give, they give the glaring mistakes. Instead of saying theft, they say dacoity. Or instead of saying dacoity, they say extortion. At that time, we can easily make it out. It is not about the extortion. Is it clear?
Yes, sir.
Actually, I would like to change the theft, but I said no. It is very much easy for you to make it out. There is no doubt at all. So, let me keep the confusion in that manner. So, 12th question. Harm meaning offense that relates to women's modesty offenses under the Public Welfare Enactment, compounding of dash. A. Modesty of the offense. B. Indecent offense. C. Sexual abuse offense. D. Trivial offenses.
Option D, sir. Trivial offenses.
It is a trivial offenses. I know that people are doing sexual abuse offenses. It is not a sexual abuse offenses because it is the trivial things. Supplementary question. What is the section say about the trivial under the IPC?
Why not 9?
You and myself also doubtful because I could not remember it. But there is a maxim is there in the law of tort. Can anyone make it out? De minimis curat lex. The law will not take into recognition of the trivial matters or triflings. De minimis curat lex. That is the terminology. Okay, now 13th question. Important doctrine, virgule, principles under the IPC. Number 1. The dash is expressly not defined in the Indian Penal Code. Rather, it is inferred from the section 301 of the Indian Penal Code. What is that maxim or doctrine? Number A. Doctrine of necessity. B. Principle of alter ego and corporate criminal liability. And C. Doctrine of transferred malice. And D. De minimis non curat lex.
C, sir. Doctrine of transferred malice.
It is a doctrine of transfer malice is the right answer. And 14th question. Mismatch the following section IPC from part A and has an explanation given in part B. I say mismatch. 341. Punishment for wrongful restraint. 342. Punishment for the wrongful confinement. And 216A, capital A, repealed. And 4. 216B, penalty for the harboring robbers and dacoits. Shoot. 341 right. There is no doubt at all. Then what about 342?
3 plus 4.
1, 2
Option
is
2
right.
is wrong.
There is no meaning at all. There is doubt. Then 216 capital A and 216 capital B, there is something wrong. So I changed it. Actually, this repeal comes down and this goes up. So mismatch is
3 and 4.
3 and 4 is mismatch. Yes, mismatch the following also. 161, public servant deserving the direction under the law. 162, repealed. 163, repealed. 164, punishment for the non-treatment of the victim. Options which I given is A, 1 plus 2, B, 2 plus 3, C, 1 plus 4, D, 2 plus 4. Which is the right option?
C, 1 plus 4.
Why? C, 1 plus 4, why? Because
161 and 2 are repealed.
161 to 164 are all repealed. So one should have to make the confusion in that manner also. Is it clear?
Yes, sir.
Yes, 16th question. Unmute and read. 16th question. Unmute and read.
Which option is the correct option among the 4 options? 1. The accused commit or attempts to commit robbery. 2. Persons committing or attempting to commit an offense and persons presence actually. 3. An aiding must not be less than 5. 4. All such persons should act conjointly.
If you closely observe, there is a mistake in one of them.
Four mistake is there.
No, all the persons conjointly can act.
Should act.
See, if you see, the accused commit or attempts to commit robbery. Both are right.
Yes.
And now come to the persons committing or attempt to commit an offense. It is not an offense, robbery. Specifically robbery. Because person present in the robbery, not in offense. A theft is there. Do you think the person is present? No. So I intentionally made an offense actually to commit a robbery here. So 2 is wrong. Then which one is the correct option? That thing which doesn't have the 2. That means which one is the right option here?
1, 3, 4.
Yes. See, feedback. Persons committing or attempt to commit robbery and person present. I removed the robbery, I put the offense. Is it clear? Say yes.
Yes.
Yes,
Yes.
17th question. Match the following section IPC from part A and the explanation is given in the part B. Part A, section 362, 391, 349, 377 and part B, dacoity, abduction, unnatural offense, force. Options A 1A 2B 3C 4D, B 1B 2A 3D 4C, C 1C 2B 3D 4B, D 1D 2C 3B 4A.
Option B 1B 2A 3D 4C.
Option B is the right answer 1B 2A 3D 4C because when you see the feedback 362 abduction, 391 dacoity, 349 force, 377 unnatural offenses. Is it clear?
Yes, sir.
Now 18th question. Mismatch the following. 1. 376 capital D gang rape. 2. 376 capital D capital A punishment for gang rape on women under the 12 years of age. And third, 376 capital D capital B punishment for the gang rape on women under the 16 years of age. And fourth, 376 capital E punishment for the repeat offenders. Options A 1 plus 2, B 2 plus 3, C 1 plus 4, D 2 plus 4. As a mismatch.
Option B 2 plus.
If you say option D 2 plus 4, WRONG.
2 plus 3 B.
B is the right answer. It is a 2 plus 3. I changed only the from up to bottom. Punishment gang rape on women under 12 years of age, it should come to the down. That is 376 capital D capital B. And the punishment for the gang rape on women under 16 years of age, it should go to up. That is the 376 capital D and capital A. See, that is the changes I made it. Is it clear? Say yes.
Yes, sir.
Proceed 19th question. Anyone? Unmute and read. I say anyone can unmute and read.
Chapter dash of attempts of commit offense under IPC. Option A 2, 3. Option B Roman number 23. Option C words 23. Option D Roman number 23. Option B is the right answer.
Option B is the right answer. D is a small Roman number or lowercase Roman number. And A cardinal, Arabic cardinal number. And B uppercase Roman number. And C in figures. No, in words. Okay, now 20th question. So the right answer is B. Is it clear?
Yes, sir.
Yes, now 20th question. Which section of the IPC is there? Under 23 chapter. A 508, B 509, C 510, D 511.
D
Yes, sir.
511.
511 is the right answer. I think it is an easy question, but sometimes it may be wrong also. Okay. Now 21st question. Which option is the correct option among the four options? A. Section 511. Punishment for attempting to commit offense punishable with the imprisonment for life or another imprisonment. B. Section 511. Punishment for attempting to commit offenses punishable with the imprisonment for life or other imprisonment. C. Section 511. Punishment for attempting to commit offenses punishable with the imprisonment for life or other imprisonment. D. Section 511. Punishments for attempting to commit the offense punishable with the imprisonment for life or another imprisonment. A simple variation I did it in all. Now, either A is the right or B is the right or C is the right or D is the right.
C.
C is the right. Because if you happen to see the A, there is a section 511, punishment for attempting to commit offenses punishable with imprisonment. No, what, where I changed it. I don't know where I changed.
Option A, you changed in imprisonment for life or another punishment, not another, sir, other. Whereas in option B, you changed offenses spelling.
Yes.
Whereas in
Yes.
option D,
That I
same.
used the American spelling. Option C, I did not use it. What I did change it in the D? Can you tell me?
Sir, and another, sir. You changed
Imprisonment for
Punishments,
life
I
or
said.
another.
No, punishments, I said. Yeah, of course, another also there. But actually, it's
Yes.
not another, it is other.
Hmm.
So, a simple variation also I can make it out so that you could know the difference between among them. So, here I given the punishment for attempting to commit offenses, punishable with the imprisonment for life or other imprisonment. When you compare this one, C is the right answer, but A, B, D is the wrong answer. Is it clear?
Yes, sir.
Yes, sir.
Now, 22nd question. The criminal law within parenthesis Amendment Act dash A 2018, B 2019, C 2020, D 2021.
18, option A.
Option 18 is the right option. 2018 is the Criminal Amendment Act. When you say Criminal Amendment Act, what are the acts come under it?
IPC, CRPC, evidence.
Of course, sometimes special laws also comes. Correctly to like POSCOS is a scopus. What is that?
POXO
Yes.
Act.
POXO Act comes under the criminal law. Also, they will make the changes in it. Okay, turn to third question. The criminal law within parenthesis Amendment Act 2018. Number of the 2018. What is the number? A 21, B 22, C 23, D 24.
B, sir.
Act
22.
21.
22, sir.
22 is the right answer. Not 21. 22 is the right answer. Act number. Okay, now, of course, everybody knows it. Act number of the IPC?
45.
Are you sure? Or 47?
Sir, 45 of 1860.
Yeah, but sometimes no, they show in the Roman numbers, sometimes they show in the Arabic cardinal numbers. But I got the doubt why they're showing in that way. It's wrong. We have to show in the way it should be given in the act. I found some places they showed me in the Roman numbers. But it is wrong. They should not supposed to show in the Roman number, the act number. Act number always in the cardinal Arabic numbers. Is it clear? See,
Yes, sir. Yes.
cardinal Arabic number, but not Roman numbers. Okay, now let us go to our point of study. 25th, stalking. Which section deals under the IPC?
24 not completed,
24th
sir.
question.
Repeat. Under A, B, C,
Question
D,
number.
which is the right? Section 354 capital A, Section 354 capital B, Section 354 capital C, Section 354 capital D.
354 capital D is for stalking, but 24th question is not done, sir.
Yes. Now let us see punishment for the criminal intimidation under the IPC. Which section deals? I say criminal intimidation. Section 504, Section 505, C Section 506, D Section 507.
505, option B.
WRONG.
507, sir.
WRONG.
506, sir.
506.
506 is the criminal intimidation. And that deals about. And what is meant by stalking? What is meant by
Stalking
stalking?
is Coming behind a woman, sir, wherever she go, following her in that way that it will cause inconvenience to her.
Either by sending the emails, or following her, or pursuing her by calling her, in all the means, without the interest of the other woman. That woman doesn't have any interest, but he is forcing. So this section includes the act of following or attempting to make contact with a woman who has already shown disinterest in a man, or monitoring her use of the internet, email, other electronic communication means. This conduct by any man will be punishable by imprisonment, which may be extended to 3 years, and for the repeated offenders, the punishment will be imprisonment, which may extend it to the 5 years and fine. So that is about the stalking. Of course, others, voyeurism and other things, you know it well. So I need not to deal it. So today class, I dealt total 25 questions, but there are many questions are there regarding the another point of our study is concerned. If you happen to see even the Bare Act, the Indian Penal Code, see the way the Indian Penal Code written is, they use the means definite article. Suppose if I give to make you confused, Indian Penal Code, the Indian Penal Code, or I will write in a different style, IPC, I will show you how I will write it. Here I am showing you. Let me drag it. Yes, the same question I can ask in this style. How an Indian Penal Code will be depicted? I say A, option A. I will write here, Indian Penal Code. And option B, I write here. Option B, I don't have electricity now in my house. That's why I could not see the letters properly. Yeah. Yes. Then I will write the option in this way also. And I will write the option in this way also. Now I'll ask you which one is correct. Yes?
Option A.
Option B, sir.
Option B is the
Option
correct
B.
answer.
B.
The reason is, I told you no, the Indian Penal Code, see the style of writing. And of course, here OF off, generally the people will not keep the capital letters, but they kept it. But generally, these propositions never be goes with the capital letters. There is a fundamental rule. And act, the first letter of it, because all things are in capital letters, hence they followed this way, ACTNO. But if it strictly is following the grammatical rules or the writing rules, N should be capital letter and O should be the small letter, ends with the full stop, because that is the one of the form of abbreviation. In the fourth form of the abbreviation, it is called shortening. Is it clear?
Yes, sir.
In chapter writing also, please note the point. Chapter writing is in capital letters and there is no hyphen between the, is it a 1 or a Roman number? Is it an Arabic cardinal number or a Roman number? Capital.
Roman.
It is a
Roman
uppercase Roman. But there is no between any hyphen also there. There is no hyphen. So they may ask you also whether there is a hyphen or not, because the way it is expressed in the Bare Act, the same way you have to express or reflect in your writing also. Is it clear?
Yes, sir.
Yeah, because from here also they can give the illustration also, because I saw in some of the paper they included the illustration and they say whether it is a correct illustration or not, or whether the liability is there or not, or whether it is a rape or not. Jai Hind.